Hello, my name is Maria Vela, and I worked on a summary of the facts of the case lines. For the background, in 2009, David Leon Riley was stopped by police in San Diego for driving with expired registration tags, and officers discovered his driver's license was suspended, leading them to impound his car. During the impound search, police found two firearms and arrested Riley. They then seized his smartphone and, without obtaining a warrant, searched its digital contents, uncovering photos, videos, and contacts that linked him to gang activity and a prior shooting. This evidence was later used to charge him with attempted murder and other crimes. Reason for petition/what happened. Riley argued that the warrantless search of his cell phone violated the Fourth Amendment's protection against unreasonable searches and seizures, but California state courts upheld his conviction, ruling that the search was valid under the search incident to arrest exception. He then appealed, and the case ultimately reached the U.S. Supreme Court to determine whether police may search digital information on a cell phone seized during an arrest without first obtaining a warrant. Parties involved: the petitioner, David Leon Riley, the defendant who challenged the warrantless search of his cell phone after his arrest; the respondent, the state of California, representing law enforcement and the prosecution that defended the use of the phone evidence under the search incident to arrest exception. The judgment. The U.S. Supreme Court unanimously ruled 9-0 that police must obtain a warrant before searching the digital contents of a cell phone seized during an arrest. The court rejected the argument that searching a phone was the same as searching physical items, like wallets or backpacks, under the search incident to arrest exception. Chief Justice John D. Roberts, Jr. delivered the majority opinion, emphasizing that modern smartphones contain vast amounts of personal information and therefore deserve stronger constitutional protection.
Hi, my name is Rebecca Esquivel. I am a part of Group 7. We worked on the Riley versus California 2014 court case. I was in charge of the issue or constitutional question in our presentation. So I do want to go ahead and start off by explaining that what was being disputed is that Davy Riley, his telephone was taken after being arrested without a warrant, and that information found on the telephone, they charged him with additional crimes. So Riley argued that this violated his Fourth Amendment right. So this is an issue because the court had never ruled on something like this before, on whether digital data should be treated differently from physical objects when applying the search incident to arrest rule. So the constitutional question in the Riley versus California case was whether police need a warrant to search a cell phone seized during an arrest, given the huge amount of private digital information phones contain. So the Supreme Court had to decide if searching a cell phone is the same thing as searching items found on a person, or if this digital data deserves greater privacy. So again, the question is just if the digital contents of a cell phone during an arrest violate the Fourth Amendment protection against unreasonable searches and seizures. So, the Fourth Amendment protects against unreasonable searches and seizures. So, generally, police need a search warrant to look through personal belongings unless there's an exception that applies. There is this long-standing exception called search incident to arrest. So, this rule allows police to search items on a person who has been arrested, such as their pockets, bags, or physical objects, without a warrant. The purpose is just to protect officer safety as well as to prevent the destruction of evidence. This dispute arises because cell phones are different from any other items. So, police are arguing that a cell phone is just an object found on someone at the time of the arrest, so they should be able to search without a warrant. However, Riley is arguing that phones contain a large amount of private information, such as his call logs, text messages, internet history, photos, and videos. Therefore, searching a phone or his phone is more like searching someone's entire life, not just the objects on them. So police need a warrant to search. So this is why this constitutional question is whether police need a warrant to search a cell phone seized during arrest, given the huge amount of private digital information on the phone. So Riley is just claiming that his Fourth Amendment right was violated. So again, the Supreme Court has to decide if searching that smartphone or cell phone is the same thing as searching any other object found on a person, and if that digital data deserves that privacy protection.
Hi, my name is Angela Vasquez, and I worked on the holding slides. Did police need a warrant to search the digital contents of a cell phone seized during an arrest? Yes, absolutely. The Supreme Court made it clear that police must get a warrant before digging through someone's phone. Even if the arrest itself is legal, officers cannot scroll through photos, messages, apps, or anything else on the device without permission from a judge. The court stressed that today's smartphones hold way more personal information than anything people used to carry in their pockets, which means they deserve stronger privacy protection. How the court decided. In a unanimous 9-0 decision, the court shut down the idea that searching a phone is the same as searching a wallet or backpack during an arrest. They said the search incident to arrest exception does not apply to digital data because phones basically contain the privacies of life. In other words, a phone isn't just an object, it's a digital map of someone's entire world. Because of that, officers need a warrant before they can open it. Who delivered the opinion? The majority opinion was written by Chief Justice John G. Roberts, Jr., who clearly highlighted how deeply personal and sensitive smartphone information is. The decision was so straightforward that no justice dissented. There was one concurring opinion written by Justice Alito, and he agreed with the court's overall ruling.
Hi everyone, my name is Isabella Esquivel, and I covered the opinion and reasoning of Group 7 for this court case. Opinion and reasoning on why the court reasoned and did the way that it did. So the Supreme Court ruled that police must have or get a warrant before they search a cell phone for its content if and when seized during an arrest. The decision was made because of how much cell phones hold so much information, and that they could find more information on a cell phone than just regularly physically searching you during an arrest. The court even emphasized that our phones are like small computers that have and store the privacies of life. This includes our texts, our photos, our data, and especially our location. So if there is no warrant, this would just be a very big invasion of privacy. As for facts or precincts that the court used or dismissed, the court looked at circumstances of the arrest, specifically when the police seized Riley's phone after the stop and search through it with no warrant. So the precinct during this case was the case of United States versus Robinson of 1973, showing that warrantless searches were allowed. However, the court highlighted that Robinson's situation was different because it dealt with actual physical objects and not media. It showed how much protection its phones actually deserved because of the sensitive things that could be found on there. However, they did believe that warrantless searches were needed because people could always go and erase and destroy the evidence before a warrantless was actually retrieved. However, people talked about how data was never really actually erased, so people could delete photos or evidence on their phones, but those photos stay for life. If people posted them, those things stay on your social media forever, so these things could always be retrieved even if they did go back and erase these things before a warrant was gotten. So the opinion and reasoning. So what was upheld or overturned? So the ruling did uphold and modify the doctrine in needing a warrant for searching a cell phone data or adding new privacy rights. So the decision did uphold the law on searches, but it didn't make it more modern because of how big data and phones and personal information on our phones has become. So it just modified it kind of to our times, I guess you could say that. So it did not overturn any other cases, including the United States versus Robertson or any other examples. But it did, however, like I said, limit that searching or specific to data or digital media, and brought in new privacy rights. So just made it more modernized because of how big cell phones have gotten. Now for our references of Teams. And these were the references used during our presentation: Cornell Law of Legal Information Institute, Riley v. California OAS, and then Riley v. California Supreme Court of Federal Cases. And then our team presentation. So we had Rebecca Esquivel doing the issue and constitutional question, and then me, Isabella Esquivel, doing the opinion/reasoning, Angela Vasquez doing the holding, and Maria Vela doing the summary of the facts in the case. And that's the end of our presentation.